try and gain some ground on protected person, unprotected speech. And we've been developing the concept of obscenity. And a key thing that we've been noting is, even though something is unprotected, there have to be limits, because if we regulate the content of speech, we may do so in a manner that undermines protected expressive speech. So we always have to deal with that. And we started with this presumption that content regulation is presumptively unconstitutional. And now we are expanding that concept. We're looking at content, of course. We're looking at categories. Notice we are distinguishing between protected and unprotected speech. And we're looking increasingly at context. Where is the speech occurring? How does that impact the content of that speech? How does that impact what type of category it is? And so in our last class, we sort of looked at what is this definition of obscenity. We looked at the Roth case, and it really didn't give us that much. In terms of a definition, you see that on page 1412. We know that obscene material which deals with sex in a manner that is appealing to a prurient interest. And the court has struggled over the years trying to define that. But Justice Stewart famously says, I know it when I see it. And so that really shows you how difficult the scope of this test is. But we go through this and we note that there is no absolute protection for every utterance. And what is interesting in the Roth case, and this doesn't develop into a test, but there's some language in the opinion, if you look on page 1413, it talks about obscenity as being utterly without any redeeming social importance. For a while, that was a component of the test, but not so much now. You always have this notion, can the state compel its own notion of morality and purity of thought on the American citizens? And that is a constant tension throughout these cases. Then we looked at Paris Adult Theater versus Slade, that's on page 414. Reaffirming Roth, obscene material has no protection under the First Amendment. So we get Paris Theater, it tells us why obscenity is unprotected. And Miller finally gives us the test. You see that on page 1417. And the test goes like this. The test is on page 1418. Obscene material appeals to a prurient interest. It depicts sex in a patently offensive way, and it lacks serious literary, artistic, political, scientific value. Hardcore. So in doing this, we sort of have a community standard, but we recognize that there is no national community standard. You see that on page 418. So we have to look at whether or not this is patently offensive under the law prohibiting obscenity. You notice that nudity alone is not enough to make material obscene. And then we ask the question under the stir prong, is there, to a reasonable person, the lack of serious, redeeming, artistic, literary, or scientific value? How do we balance this notion that thought control is prohibited by the state versus a community should be able to determine its own moral environment? Should the government determine morality? And the state cannot prohibit Lady Chatterley's Lover because it depicts adultery. That's a literary classic. But we also have this notion that obscenity could lead to antisocial behavior, virulent violence against women. And so that's the tension that we have here. There's also a discussion starting on page 1421 of the scholarship of Kathleen McKinnon and Andrea Dworkin. They've argued that pornography should be excluded as a form of sex discrimination outside of the protection of the First Amendment. And some states have even adopted McKinnon's approach, but which has been criticized as too broad. What is deemed unprotected pornography? So you have this case of Hutnet on the top of page 422. That was a version of McKinnon's statute. But notice again, we had the same problem that we had in REV and other cases. The court concluded that this was unconstitutional viewpoint discrimination because it prohibited some views of women in society and not others. The ordinance discriminates on the ground of the content of the speech treating women in an approved way. So we had this moral standard of the way we want women and people in society to be viewed. That's lawful, no matter how sexually explicit. But treating women in a disapproved way and submissive in matters of sexual conduct is unlawful, no matter how significant the artistic, literary, music, or political quality. So looking at that content, the state is making a decision about how women should be depicted. The court concludes that that's viewpoint discrimination. That was a lower court decision, 7th Circuit. So now we are dealing with what we're dealing with today, New York versus Farber. Child pornography, unprotected, should be unprotected. But it is the way that the state regulates it that brings the First Amendment into play. So there's no dispute that we are talking about categories of speech that are unprotected. But our major concern, again, is how is the state regulated? Because we don't want to undermine a protected expressive activity. So the first case is on page 1422, New York versus Farber. So how do we go from these definitions, like we have in Roth and Miller, trying to navigate those definitions, and prohibiting child pornography? You want to give states great leeway to regulate this type of unprotected speech, but what are some unintended consequences that we have to look at under the First Amendment? We're making some value judgments about content. So what are those value judgments? What are those value judgments? And do they work? So we're not making an argument that the speech is great. We have to figure out how it should be regulated. So this case stands for this proposition. This is what we need to examine. Government can prohibit the exhibition, sale, or distribution of child pornography. Notice this, even if it does not meet the test for obscenity. So how far can this go? How far can this go? What do you think? Is there more?
Well, they talk about the competing interest of the state versus freedom of expression, and that they ultimately say that their interest in protecting children outweighs the interest in protecting freedom of expression in this case.
Okay. Now, you said in this case. Why do you say it like that?
Well, just because it depicts children.
Mm-hmm. Well, what about running the risk of protecting something that is protected expression? We're giving the states all this leeway. It's almost like, okay, this is child pornography, regulate it any way you want to. This is unprotected, and that's fine. And as you said, in this case, it works. But should we be concerned with other cases if we adopt this proposition of how the state should regulate speech? So regulating pornographic depictions of children is really bad. We want the state to deal with it in any way that it can. But should there be a ceiling on the state's power in terms of how it regulates even unprotected speech under the First Amendment? Yeah. What do you think? How do we make sure that this doesn't get too broad? I mean, I could start, what if I'm the person who drafts this and I have this view about morality and I say, well, yeah, child pornography is bad, but even if it's in a textbook and we're talking to social workers or even in law school class, we shouldn't even have this case in here. Still, it makes me uncomfortable. I don't like it, and let's wipe it off the face of the earth. Yeah. Go ahead. What do you think?
I think there just has to be a cost-benefit analysis. What is the benefit of having that versus what is the risk posed to children potentially?
That's true. Okay, that's a good point. So, cost-benefit analysis, how would you construct a statute that sort of did that without undermining protected expressive activity? And this is what I'm getting at. This case is kind of, not long-winded, but it goes through, this is why we're doing it. We want to safeguard the physical and psychological well-being of minors. We want to destroy this distribution chain. We want to avoid the stigmatization of children having a permanent record of abuse on the internet or wherever in photographs. We want to close this distribution network. And we also say that the Miller standard that we have been developing is really unsatisfactory when we deal with child pornography. I mean, that purely interest really doesn't have any connection with the impact and harm that is done to children physically or psychologically. And we want to get at this economic motive for illegal activity. And we want to make sure that reproduction of children engaged in lewd sexual acts is effectively regulated. And we want to classify child pornography as outside of the First Amendment. So all of that is fine. And we say that we have a separate test from Miller. But how do we make sure that state power doesn't expand? We're fine saying it in this case, but what about other cases? What do you think?
I would just go back to the cost-benefit analysis.
Okay, so how does that balance work?
I think, again, like competing state interests versus, I think if your First Amendment expression is infringing upon like greater interests, I don't think that can be protected.
I mean, so this is what the thing about this. It says the value of permitting live performances and photographic reproduction of children engaged in lewd sexual acts is exceedingly minor, if not de minimis. We consider it unlikely that visual depictions of children performing sexual acts or these lewd acts will constitute an important necessary. So it's almost like it's going beyond, we know when we say this is just de minimis, it's unprotected, we can distinguish this. Notice this, a person over the statutory age who perhaps looks younger could be utilized, so that even though that's unprotected, unseemly speech, that's something that's not reached by the statute. And there are other modes of expression that this statute doesn't impact. And so that's the court sort of reading how the statute works. But in practical reality, is there a way to limit the power of the state? That's what I'm getting at. Michelle?
I was going to say they kind of limit what is considered child pornography.
Okay.
And they talk about it in the next case, but they focus a lot on whether it's an actual minor being used in production of the stuff.
Now that's interesting. So good other stuff. So that sets up the next case. Look at this. So little sentences mean a lot in these cases. Look on page 1424. This sort of says, this is why this case is right before Ashcroft. These cases are selected and edited for a reason. So the answer to Ms. Limore's cost-benefit analysis is we're going to look at the words of the statute and look at what it actually prohibits. And in this case, and hopefully in other cases, we are limiting this prohibition, this regulation, to works that visually depict sexual conduct by children below a specified age. Below a specified age. We don't want children of tender age or any age really to be involved in this. And so notice this sentence, the value of these things are de minimis, but even though it's unprotected, there's still outlets for speech if you want to engage in this. The state is not telling you what to say. Notice, as the state judge in this case observed, if it were necessary for literary or artistic value, notice it's hooking it up to something that's redeeming, a person over the statutory age who perhaps looks younger could be utilized. So this is an actual child being utilized. We're going to prohibit someone under the age, of course, but someone over the age who just happens to look young would not be prohibited. That could be utilized. You see that in the next case, as Ms. Shaw pointed out, Ashcroft. And there's a conclusion to that on page 1428 where the court specifically references Ferber. Ferber is talking about actual impact on actual victims, and that's how we limit the statute. So the court expressly looks at the state court judge and how he looked at the facts to see how this can be limited. Completely separate from the purity and interest, because Miller really talks about adult activity, consenting adults, and that type of thing, and can you expand state power in that way? So it's appropriate to talk about purity and interest. Here we're talking about the impacts, physical and psychological, on the child. Brennan and Marshall, they concur. And notice they just want to make the point that, of course, this is unprotected speech. There are limited classes of speech in categories, the expression of which does not raise serious First Amendment concerns. They don't have exceedingly compelling social value. The state has a compelling interest in regulating them. And they also want to carve out, well, there is some protected expressive conduct where this type of regulation would not be de minimis. Depiction of children that are in themselves serious contributions to art, literature, sciences, by definition, simply not de minimis. So this case can be in the book and talk about this type of obscenity because it is important to developing you as lawyers. Those are some depictions that are not de minimis, and the state regulation would not get at that. And so that's why they concur. They agree that states have to have leeway. There should be a limit to that power. Miller doesn't apply because there we're talking more about consenting adults. Here we're trying to protect the devastating impact on children. Ashcroft, page 1425. So we go from this proposition that the government may prohibit the sale, distribution of child pornography, even if it doesn't meet the test for a Miller. We're not talking about really appearing interest. Our focus is on the child. The conduct to be prohibited must be adequately defined, and that's what we did when we looked at the statute. And this statute works because it's limited to depictions that visually portray children below a specified age. So that's the limit. We're concerned about impacting protected speech, but the court is going to look at the statute and how it functions and make a determination about whether or not it undermines free expression. So now we have Ashcroft versus Free Speech Coalition, fairly recent case. But now we have technology mixed with the First Amendment. And so what happens now when you really don't have an actual child, but you have a visual depiction of a child engaged in these lewd sexual acts? Obscenity, right? What about that? So notice this proposition. You get this sort of sums up everything. It's one little sentence. Something like this. The government may not suppress lawful speech as the means to suppress unlawful speech. So yeah, it's good for you to get at this unprotected stuff. It doesn't contribute anything to the marketplace of ideas. It debases us as a society. But again, the way you regulate it must be in compliance with the First Amendment. So what happens in Ashcroft? Why in Ashcroft do we say that this is unconstitutional? What makes this unconstitutional? Child Pornography Protection Act, 1996. You want to know whether this abridges the freedom of speech. And so we're looking at two components of the statute. The court really looks at three things, but the computer morphing isn't challenged. You see that on page 1427. But we're really looking at two components of the CPPA. One is Congress has decided to prohibit any visual depiction that appears to be a child in these sexually explicit situations. So we have the statute that prohibits any visual depiction that appears to be. So this deals with virtual child pornography, computer-generated images. And then we have another section that says, similarly, defining child pornography to include any sexually explicit image that was advertised, promoted, presented, described, or distributed. So this is more of the distribution chain we're trying to get at, in such a manner that conveys the impression that it depicts a minor engaging in sexually explicit conduct. So we are prohibiting depictions that appear to be children engaged in these acts, virtual child pornography, and we also want to get at the market distribution chain, where we are distributing something that conveys the impression that it depicts a minor engaging in sexually explicit conduct. And this case starts off with a proposition that we started off with even when we were talking about overgrowth. Look at the language about standing. This is so important that even though it's unprotected, someone can bring this claim because we are concerned that the state might, in its regulation, impact protected speech. This case provides a textbook example of why we permit facial challenges to statutes that burden expression. That's that standing notion. So you may not have the classic Article 3 standing that you learned about in Common Law 1, that concreteness and adversarialness. Here we're taking a different, more relaxed approach because the state's power can be used to impact protected speech, and we're really concerned about that. We have a strong presumption against the state regulating the content of speech. So we have these two statutory provisions. What does the court say? What makes this overbroad and unconstitutional? We're back to where we started again with overbreadth and vagueness. Appears to depict, conveys the impression. Yeah,
so they're clarifying the Farmer rule by saying, in that case we were talking about actual children being harmed, and the root of the law being upheld in Farmer was that there were actual children being harmed, and it was furthering child abuse. In this instance, this would capture materials produced with no children involved. They're computer generated. So they're saying it captures too much material.
Okay, that's good. I'm with you. So the statute is prescribing, the court says, the visual depiction of an idea, not real. Something, we may not like it, but this is an idea and we let it flow in the marketplace of ideas. You can't be so overly broad, government, in your suppression of this unprotected speech that you undermine protected speech. So that shows that it's overbroad. But there are a lot of good reasons, though, to prohibit this. For example, virtual child pornography. What if the technology is so advanced that we can't even tell the difference? That these computer-generated images actually look real and people think that they are real, and then that will make pedophiles whet their appetites. That increases the demand for this. The market chain sort of expands, and we have this burgeoning market of virtual child pornography that is almost indistinguishable from what we said could be prohibited in further. What can we do about that?
Well, the court didn't lie that was going to be a problem. They found there was insufficient evidence that would ever be the case. But I think today, with deepfakes and all the things we're seeing, it is becoming indistinguishable. So I think Justice Kennedy's wrong. Okay, you
lost me. I need to. I'm not holding anything. What's deepfakes?
So someone else will explain this better than me, but computer-generated videos that are highly realistic depictions.
So they don't look cartoonish. They could almost look just like us now. Okay, wow. So yeah. So and this is over the case. So this might have to catch up. That's interesting. So, but the court seems very confident in 2002 that Ferber stands for this position that you can distinguish virtual images from real images. And Ferber itself recognizes virtual images as an alternative and permissible means of expression. And we don't want to undermine things like Shakespeare or Traffic or American Beauty. So speech within the rights of adults to hear cannot be silenced completely in an attempt to shield children. Cannot overregulate the unprotected if you're going to undermine protected speech. Ms. Moran, go ahead.
Oh, well, as to your first question, I think as the court was saying that argument had two flaws about indirect harms being sufficient, because they said Ferber stood for how child pornography was made and not on what was communicated. So because they don't have actual children, they're not harming children, and so there's no need to protect anyone. And then also, kind of grossly, Ferber did not hold that child pornography is by definition without value.
So, but okay, that's good. So do you think the court adequately takes into account harm? Because it seems like, well, this is an idea, we don't like it, marketplace of ideas is lewd, but no one's getting harmed because this is just virtual, and we don't want to go as far as undermining protected speech, so we're just going to leave it alone. But does the court accurately assess what harm is in this context?
I mean, I would kind of say no. Like they say that the government has only shown a remote connection between like the harm and like the faults and impulses and results of child abuse.
Right.
So I would actually probably go on the other side of it, that there is more harm than what the court is saying.
Good. So I guess that's my next question. How would we sort of give proof that this is something that could be regulated? Because the court is, and again, this is 2002, so technology has moved up a little bit quicker, so some analysis might change if we get this again, but the court is really confident in saying there's no direct connection between speech that might encourage pedophiles and any resulting child abuse.
I think for me, like, the big issue is that the law also doesn't even reach obscenity in the first place. Like, it's just saying sexually explicit, which is super subjective. It's not
Yeah.
even describing, it's not even saying child porn in obscene areas. It's just saying sexually explicit. And so that is also another layer that being too vague and overbroad. And that's how it could reach so much protected speech.
Now, okay, good. So if it refined how speech functions in context, would that help answer your question?
Yeah, I think they need to define it more so that they're actually targeting obscenity as well, or at least attempt to more.
Good. Tell me what you mean when you say define obscenity, because we've been having difficulty defining that. So in this context, how would you define it?
Well, like the opinion talks about how it's so vague that it could limit like Romeo and Juliet, and like it's so vague. Sexually explicit means like teenagers making out or
Right.
anything. So like
And
it's
notice,
more than that.
yeah, and notice in modern times we've sort of popularized that romantic metaphor. I mean, there's no consummation or anything in Romeo and Juliet and Shakespeare's version, but we've sort of made it a little bit more different, and that shows context and what it means. But that is expressive conduct, and so context is definitely going to drive how we view that content.
So I guess to the question of like how the court addresses harm, there are three things that stick out to me.
Okay.
One is the counterpoints to one that child pornography induces pedophiles conduct. Two, that ban deters that it deters the behavior, and three, that this virtual version makes it able to prosecute real. And it seems like in all of those cases the court just kind of like sidesteps the question of, doesn't react to like the issue of harm so much. It's just saying like, well, this is overbroad. So like if I said when to the point that it induces pedophiles towards conduct, Kennedy just kind of says, well, the right to think is the beginning of freedom, and speech must be protected from government, because speech is the beginning of thought. That doesn't even address the argument. So it's like, on deterrence, he kind of says like, well, actually, you know, why would a child pornographer, the incentives are like kind of off in that argument. Like, why would a child pornographer risk, you know, sorry, I'm kind of like,
Risk abusing real children when they could deal with virtual images.
Right. And
few pornographers would risk prosecution by abusing real children if they could get fictionalized, computerized images.
yeah, and it seems like, I mean, that seems to have been, you know, as Katie was saying, like, deepfakes and everything else, it seems to, over time, that's, you know, it's still a problem. And then, yeah, I'm kind of,
And then no.
it seems like it seems like he sidesteps the question.
Right, and I think the reason that he doesn't really conceptualize the consequences of harm is because he looks at it, this isn't even real, so this isn't fervor, and we really don't have to deal with all these. All these things aren't real because they don't emanate from an actual victim with actual harm. So we can't show the connection between pedophiles and this type of child abuse. We can't really show that pedophiles will move on to real children if they can not be criminally prosecuted if they deal in virtual reality. And the distinctions between the difficulty in prosecution, well, that's why we have prosecutors that can make that determination, but again, no harm here, so there's nothing for the prosecutor to do. But that all emanates from this notion that there is nothing to remedy, because there's no injury. Now, Justice O'Connor does something interesting. She does sort of a half and half thing. What is she getting at? She would uphold the ban on pornographic depictions that appear to be minors. She would say that's unconstitutional. But she would strike down the portion of the statute that says conveys the impression. And so what is this better reading? She says, notice what she says, I can narrow this by reading it in the appropriate way. So I think she thinks that she's narrowing this by looking at appears to be and offering a narrowing construction. What is she doing there? See, a better interpretation of appears to be would be to add this language, is virtually indistinguishable from. And she thinks that that interpretation would not cover the examples that are provided to attack the statute. So this narrow interpretation, she says, saves the statute. And saves it from discriminatory enforcement. But how would you sort of apply that? Appears to be virtually indistinguishable from actual victim. And so this is sort of a fallback position as well. Her test isn't that great either because she has to add this sentence. This court has never required mathematical certainty or meticulous specificity from the language of a statute. That's fine, but a person could get 15 years for this if we can't distinguish what is protected and what is unprotected. So she would strike this appears to be provision only insofar as it applies to the subset of cases involving youthful adult pornography. So if you have someone who looks a certain age but really isn't, she doesn't want that to be reached. And then conveys the impression is just too broad. Then Chief Justice Rehnquist and Justice Scalia say, defer to Congress's finding. And if a limiting instruction means anything, if we defer to how Congress defined this, we all know that we can make distinctions about what is protected and what is unprotected. The Chief Justice suggests that everyone knows how to distinguish between protected and unprotected speech. And it's particularly subject to regulation if we're talking about something that is pandering, commercialized. It says that on about page 1431. So, top of page 1432, after this, we have a Williams case, which tries to refine some of the things in Ashcroft. There.